Thank you for joining us here on KARE 11 News Now. I'm Jason Hackett. Happening right now, opening statements are beginning in the burglary case of State Senator Nicole Mitchell. She's accused of breaking into her stepmother's home in Detroit Lakes last April, which is about 3 hours northwest of the Twin Cities in Becker County. Court papers say police found a crowbar by the basement window. In the criminal complaint, Mitchell argued her stepmother had stopped talking to her, so she was trying to retrieve her late father's belongings. Let's head into court to hear opening statements.
Sir, were you going to use your hearing assist device? I was just waiting for you to get that up and running. Are you able to hear me? Are you able? Testing, 1, 2, 3. Caleb, would you assist, please? All right. Testing, 1, 2, 3. Okay, we got the thumbs up, so we have that hearing assist. Good morning, ladies and gentlemen. And when you arrived this morning, you probably observed what we've all observed here, is that it's quite warm in the courtroom. When I arrived to court this morning, I was informed that the courthouse did not have air conditioning. A few moments ago, I was informed that the air conditioning has been restored. It may take a little bit here to get us to a comfortable temperature, so I ask for your patience in that. Before we begin with the trial, I am certain you've noticed the tripod camera and microphone just off to your right. Under Minnesota law, news agencies, the press, may petition the court to have a video camera and still camera in the courtroom during a trial to audio and video record and photograph the proceedings. There has been a request to do so in this case, and I have granted the request with strict limitations and restrictions. One rule or restriction of the law they operate under is that they cannot video, audio record, or photograph you, the members of the jury. There is only one video audio camera and one still camera. The video camera is set at a strategic position and angle to ensure that they do not video record the jury box, meaning you, the members of the jury. The rule also provides they cannot audio, video record, or still photograph voir dire, which was the jury questioning yesterday, which is why you did not see any cameras in the courtroom yesterday. You are not to concern yourself with the cameras during this trial. Your focus must be on listening to the testimony, the attorneys, and this court. As I mentioned, this trial is about to begin. During the trial, you are going to hear testimony of several witnesses. You will have to make judgments about the credibility and weight of their testimony. Be patient and listen to the testimony of all the witnesses. Keep it all in mind until you have heard all the evidence. As you listen to the witnesses, you should take note of such matters as the witness's interest or lack of interest in the outcome of the case, their relationship to the parties, their ability and opportunity to know, remember, and tell the facts, their manner, age, experience, frankness, and sincerity, or lack thereof, the reasonableness or unreasonableness of their testimony in light of all other evidence, and any other factors that bear on the question of believability and credibility. In the last analysis, you should rely on your own experience, judgment, and common sense. You may take notes during the trial, but you should not feel required to do so. The most important thing is to give full attention to the testimony as you hear it. You should keep an open mind about all the evidence until the end of the trial, until you have heard the final arguments of the attorneys, and until I have instructed you in the law. Evidence is what the witnesses say in any exhibits submitted to you. What the attorneys say is not evidence. However, you should listen attentively to any statements the attorneys make. Those statements are made so that you can better understand the testimony. You will decide the facts from evidence introduced during the course of the trial. Evidence can be in one of two forms: direct evidence or circumstantial evidence. A fact is proved by direct evidence when, for example, it is proved by witnesses who testified to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proved by circumstantial evidence when its existence can be reasonably inferred from other facts proved in the case. During the trial, an objection may be made to some evidence, and I may sustain or overrule the objection and direct that a question not be asked or answered. You should not speculate about what the possible answer would have been. If I instruct you during the trial to disregard some statement that a witness has made, then you must disregard it. There are things you should not do during this trial. You are not investigators. You are not to go out and do any looking, and you're not to speak or not to ask people about this matter. Above all, you must not talk to anyone who is involved, the lawyers or the witnesses. You should not discuss this case among yourselves during the trial. At the end of the trial, you will have as much time as you need to discuss it, but that is at the end and not during the trial. When you go home during the trial, your family and friends will be curious as to what you are doing. You may tell them that you are sitting as a juror in a criminal case, and that is all that you should tell them. You may also tell them that you will tell them all about it when it is over. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about this case and do not talk at all to anyone involved in it. Do not read about this case in newspapers or listen to news about it on radio or television. Do not talk about any of the people or any subject involved in this case with anyone. Do not share information about the case in writing, by email, by telephone, on the internet, or by any other means of communication. You must not email, blog, tweet, text, or post anything to Facebook, Twitter, or other social networking sites about this trial. Do not visit any chat rooms in order to discuss this case. Are the attorneys prepared with opening statements?
Yes, Your Honor.
All right. Mr. McDonald.
May it please the court, counsel, ladies and gentlemen of the jury, I know I did something bad. Those were some of the many words of Senator Nicole Mitchell in the early morning hours of April 22nd, 2024, when detained by law enforcement. I ask that you specifically remember those words throughout this trial. I know I did something bad. On the night of April 21st, 2024, Carol Mitchell, then a 74-year-old widow, went to sleep in her Detroit Lakes home. It was the last time that she would feel safe in that home. That is because in the early morning hours of April 22nd, the defendant broke into Carol Mitchell's home. She broke in through a basement window using a crowbar and was caught red-handed a short time later. This case won't be about